Hello, welcome to the Specialty Contractors Council webinar on employment law. The SCC, we're one of the councils in the BIA, and our purpose is to encourage greater participation in the BIA from members that hold an A, B, or C license or are an associate member. We create value by presenting opportunities for professional growth and success via educational seminars, such as this one, and networking events that offer a forum for relationship development with builders. So I would like to introduce our speakers today from Shepherd Mullen. We have Keen Morris. He is a partner in the Labor and Employment Practice Group of Shepherd Mullen. His practice encompasses both employment and traditional labor law. He litigates employment action before state and federal trial and appellate courts, including disputes involving wage and hour class actions, PAGA actions, whistleblowing, wrongful termination, discrimination, harassment, breach of contract, trade secrets, unfair competition, and related claims. Keen also has extensive experience across the traditional labor field, including providing strategic representation to employers concerning union-backed corporate organizing campaigns, collective bargaining, PLA negotiations, labor arbitrations, and unfair labor practices and representation proceedings before the National Labor Relations Board and the U.S. Courts of Appeals. We also have Whitney Hodges with us. Whitney is a partner at Shepherd Mullen in the Real Estate, Land Use, and Natural Resources Practice Group in the firm's San Diego office. Whitney's practice focuses on the representation of clients involved in real estate development. She advises and represents major residential, industrial, commercial, and mixed-use development projects, as well as Native American, Indian tribes, and renewable energy developers through all phases of the land use regulatory process and environmental compliance, including litigation. Whitney is also involved in a number of industry organizations and is an adjacent professor of the University of San Diego. Hopefully I got that right. Yes. Welcome.
Great. Thank you, Stephanie, and thank you for BIA for having us. I know there's absolutely nothing more thrilling than having a bunch of lawyers talk to you about recent legislation and case law updates, but we really appreciate you spending your lunch hour with us. We are excited to chat with you about some of the more recent and relevant changes in labor law and how it intersects and impacts the development industry. And Kirsten, now if you're able to, if you can bring the presentation up, that would be most helpful. Great, thank you. And with me today, as Stephanie pointed out, is Keen and Kayla. They're from our San Francisco office, and they are in labor and employment. You also have Kirsten, as well as myself. We are in our San Diego office, and again, we are just very excited and happy to be here. Shepherd is a huge supporter of BIA and just excited to be able to talk with you guys today. And without further ado, Kayla, I will let you take it away.
Great, thanks so much, Whitney. So here's an overview of what we're going to be covering today, and I will kick us off with one new really big piece of employment legislation. So effective this year, just starting January 2023, is this new Pay Transparency Act requirement. And it's important not only to understand what the requirements are to comply with this law, but also to understand that through this pay scale information being reported, this might bring up liability for equal pay claims, which I'm going to talk about a little bit later. We haven't seen a significant increase in equal pay claims because this law is so new, but we do expect, based on this information being provided to employees and to the state, that this is possible. So the main requirement, and this applies to all employers with over 15 employees, they have to provide pay scale information in all job postings. You've probably seen this around a little bit so far with the pay ranges. And they also have to provide pay scale information to employees when they request it. Now, the requirements are a little bit more in depth. Once you have over 100 employees, you also have to cover pay rates with a combination differentiated by race, ethnicity, and sex within the different job categories. And this requirement also applies to labor contractors. Also significant is that the employer has to maintain a record of this pay history data for 3 years after termination. So as you can anticipate, this type of information being held and recorded by an employer could come up later, could be discoverable. So this is also something we keep in mind for potential liability down the road. So what do you actually have to disclose in your job postings? Well, what you have to show is salary or hourly wage info, what you reasonably expect to pay for the position that you're posting. And this also applies if you're posting the job on a third-party site, such as LinkedIn, that salary or wage rate information has to be on there as well. And we see across the country, there are various states passing similar requirements. So if you happen to be doing developments in other states, something to keep in mind as well. And the violations for not including this in your job postings can be quite significant. The penalty is between $100 and $10,000. And the statute of limitations is essentially 1 year after an allegedly aggrieved individual finds out about the violation. That's how long they have to file these claims. And they do have a private right of action, so they can bring a suit in their own right. You have basically one chance to fix it. The penalty gets waived for the first violation if you comply for all following opening positions. And if the employer does fail to keep these records, that's a rebuttable presumption against them in favor of the employee's claims for violation of this new law. Another thing to keep in mind is this is subject to PAGA, which Kian is going to talk about in a lot more detail later, but this could kind of make the claim a lot larger than just a single individual. So specific to what you have to report, and this is really coming up soon, every year you're going to be required to submit reports of this pay scale information to the state. The portal is actually open right now because the deadline for the 2022 reporting year is May 10th, so next month. And if you go on this portal, you will see that the Civil Rights Department has provided some like template Excel spreadsheets. You can kind of see what it might look like. And the specific things that you have to include on there would be mean and median hourly rate. And then if you have those higher, if you have over 100 employees, you have to include additionally those categories of race, ethnicity, and sex. And keep in mind, this will be for the prior reporting year. So this May 2023, we're going to be reporting for the 2022 pay scale information. And you will report by location. So if you have different addresses, different locations, you'll have like separate information for each. The violations for failing to submit this report to the state are $100 per employee or $200 if you violate for a second time. This also applies to labor contractors, which I know that might be a lot of the folks that you interact with. So keep in mind, there are very similar requirements for labor contractors, a couple of small nuances. There is a little bit more specification on this on the Civil Rights Department FAQs that they have posted. And the penalty is similar as well, and it will be split with a labor contractor. Now, one thing I did want to note to keep in mind is that as you're getting ready to put out this information, you can't be asking applicants that apply for their salary background, just something to keep in mind when you're creating those pay ranges. So we do kind of anticipate that potentially this pay scale information being disclosed to not only employees, but also the state could mean that this is information that could be used by employees to help prove their claims for equal pay claims. So we just wanted to provide a little bit of context to explain more what this framework would be for these type of claims. So we have something called the California Equal Pay Act, which was amended in 2016 by the Fair Pay Act, which added a little bit, really broadened the act a little bit more. The basic framework is a burden shifting framework where we start off with the plaintiff having the initial burden to show that the employer does pay workers of one sex, race, or ethnicity more than that of another. And this is specifically for substantially similar work under substantially similar conditions. And it used to be equal work. And so now the definition is a little bit broader, substantially similar work, and there is case law that defines that term. After the plaintiff meets their initial burden, then the employer can show an exception, and we have 4 defenses that the employer can use for that. And then lastly, the plaintiff can overcome that by showing pretext. So a little bit more context, and you guys, we're going to, this is on there for you guys to read in more detail, but just to keep in mind, this is a little bit broader than just wages. This is a little bit more detail. So the substantially similar work is based on skill, effort, and responsibility. So this is something that you have to kind of closely look at when seeing what your liability might be. And keep in mind that it's not just among sex, but also race or ethnicity, same framework applies. So the main 4 defenses that would allow you to have a pay differential between these groups would be 1, a seniority system, paying employees that have been there longer, more, a merit-based system, some system that's based on a quantitative or quality factor of your production, or lastly, a bona fide factor, which might be what is the educational background of this individual, their training, or their years of experience. And this 4th category does focus on it being a job-related factor, and it can't kind of be derived from or just a substitute for a sex, race, or ethnicity differential. It has to be kind of aligned with what is the business purpose. So these are all things to keep in mind as you produce that information, that pay scale information to the state. Overall, what we do recommend is kind of when you're preparing to provide that information, you do an internal audit. You do an internal audit and see what your liability might be if you're seeing a lot of disparity between groups in your pay scale. Hopefully you guys don't have issues with this, but if you do, feel free to reach out. And now I'll pass it over to Whitney.
You would seriously think after 3 years of Zoom, I would know to take myself off mute, but I swear this happens once a week. My apologies for that. All right. Well, given the amount of labor required for the commencement and completion of both public and private development, prevailing wage, project labor agreements, or PLAs as we call them, as well as workforce requirements have become a hot topic for both litigation and legislation. The California prevailing wage law was passed in the 1930s as a way to ensure that workers on public projects were paid at prevailing market rates. But in recent years, the prevailing wage law has been dramatically reshaped and expanded, and it has become a tool for workers to demand union wages on virtually any construction project in California. And these claims can increase the cost of major construction projects by millions of dollars and can actually be brought years after the construction is complete. The dividing line separating which privately undertaken improvements that are subject to prevailing wage requirements from those which do not has become less and less clear since the 1930s, and it's quite a murky area. The result is that some contractors, after bidding a project as a purely private undertaking, not subject to the labor code's public improvements prevailing wage requirements, learn that they have incorrectly bid their labor costs. And this can lead to a huge financial risk that is actually borne by the contractor themselves. So there are some notable cases, and again, I know case law is absolutely thrilling to everyone that is also not an attorney, but just to run through it really quick. In 2010, Azusa Land Partners versus Department of Industrial Relations was decided, and this greatly expanded the reach of California's prevailing wage law to cover private works of construction that had never before been deemed quote unquote public works subject to the prevailing wage law. As a consequence, developers and builders would have to consider closely how they structure their development and agreements so as to avoid unnecessarily and inadvertently imposing the prevailing wage law requirements on privately funded construction. And this is very difficult to do, as often most private projects have a number of public improvement components, including public infrastructure, public parks, things of that. So it became very, very critical that developers and contractors were starting to draw a bright line as to what would be public so as not to taint the entire private development itself. So just by way of background, the prevailing wage law requires these workers to be paid union wages for anything that's considered a public work, as determined by the state. This definition was greatly expanded under the Azusa law, or the Azusa determination. However, most recently, the Supreme Court of California clarified that the statutory definition of public work was generally limited to fixed structures on land and not rolling stock. Separately, the Supreme Court held that public work must be expressly defined under the labor code. These decisions were Busker versus Wabtec Corporation and Mendoza versus Fonseca McElroy Grinding Co. And these were decided in August of 2021. In these cases, the court rejected both plaintiffs' employees' reading of the law that would have significantly expanded the kinds of work for which prevailing wages must be paid. These cases are important to the construction industry companies engaged in public works and for construction unions. Sometimes really though, the best way to avoid a prevailing wage dispute is to negotiate in advance an agreement with the unions known as project labor agreements. And this is a way to sort of bypass the threat of a prevailing wage law violation coming years and years after the construction is actually commenced and in some cases completed. So what we're seeing a lot more recently in legislation, not necessarily in response to the litigation, but more as an indication of sort of the ways to incentivize development, but also as a way to address the cost of living here in California, is that a number of legislators are introducing legislation that includes a prevailing wage, a workforce requirement component, or a PLA component. One of the more identifiable laws that we've seen in recent times is SB 35, which was enacted into law in 2017. And this created a CEQA exempt streamlined process for affordable housing projects, again, as a way to address the housing crisis here in California, and also to try and unburden developers with the time and cost extensive CEQA process. So as part of the requirements of SB 35, these projects were going to have to be subject to prevailing wage requirements. And for a number of contractors, oddly, the headache of CEQA was more palpable and bearable than actually trying to figure out prevailing wage requirements and some workforce requirements. So unfortunately, despite the lofty intent of SB 35 for providing housing, we don't often see it utilized because of some of these quote unquote sweeteners that the legislature has added to address these prevailing wage requirements.
Thanks, Whitney. And then the next development, legislation that goes into effect this year is AB 2011. And this is just a program to enable by right development of 100% affordable and mixed income housing developments. It creates a CEQA exempt process that requires either a 90-day decision period for projects with less than 150 homes or 180 days for projects with more than 150 homes. And the main labor requirements that apply to AB 2011 is that it requires prevailing wages and as well as health and labor benefits for projects with over 50 units. But it does not require a skilled and trained workforce requirement. And then again, apprenticeships and specified healthcare expenditures are required for developments of 50 or more units. And also going to effect this year is the Neighborhood Homes Act, or SB 6, which also has a labor component. This bill allows residential or mixed-use development projects with at least 50% of square footage dedicated to residential use in commercially zoned parcels of 20 acres or less. It also provides an expedited review process if SB 35 is invoked, but it doesn't have a affordability requirement. And it does have a little bit more rigorous labor requirements. It requires prevailing wages, as well as a skilled and trained workforce requirement, unless there are fewer than 2 construction bids received for the project. And with that, I'm going to hand it over to Keen to cover arbitration and PAGA updates.
Great, thank you. Yeah, so in the area of arbitration and PAGA, there's been a number of important developments over the past few months. As you may know, wage and hour law in California is pretty significant, and there's more wage and hour claims that are filed in California than any other subject matter, regardless whether it's an employment context or not. The other mechanism, aside from class actions that plaintiffs pursue, is through PAGA, which is the Private Attorney General's Act statute. This was passed a number of years ago. It was actually the last piece of legislation that Gray Davis signed after he was ousted from office. And it's sometimes referred to as the sue your boss law because it basically makes it extremely easy for employees to sue employers for alleged labor code violations. And essentially under this PAGA statute, it allows not only employees to sue on behalf of themselves, but on behalf of other employees that have been allegedly aggrieved. And once the individual files with the California Labor Commissioner, the Labor Commissioner will authorize an employee then to pursue a case in state court. And in those circumstances, basically the employee is acting on behalf of the state in pursuing the claim. And so it's resulted in thousands of these types of claims on an annual basis. And we certainly see all types of PAGA claims being brought against employers in your industry, especially as it relates to joint and single employer liability. Next slide. So before we get into the developments in this area, I briefly wanted to touch on private arbitration and why we think it's so important. Would strongly recommend you consider rolling out arbitration agreements for your employees if you don't already have them. Some of the pros associated with arbitration is it's typically faster. It's a simpler process. You can control a lot of the things that you can't control in state or federal litigation, like discovery, selection of the arbitrator. And in most circumstances, if you choose the right arbitrator, you're better served than putting a case in front of a California jury. And then probably the most important aspect of this is you can have a class action waiver in an arbitration agreement, which would essentially prevent a class action moving forward and would have to be a bunch of mini arbitrations through an arbitration agreement. And in most cases, plaintiff attorneys don't want to pursue those. That's not worth their time. And that's why the class action waiver is so effective. There's also the ability to have a PAGA representative waiver under some circumstances, which we'll talk about in a few slides. Next slide. In terms of the cons of arbitration, yes, there are some nuances to it and some components that are unique to arbitration. If you select the wrong arbitrator and you lose in arbitration, then you have a very limited right of appeal. And there's also the inability most of the time to dismiss claims either through a motion to dismiss or a motion for summary judgment. But all things considered, again, we think arbitration is worth it for employers, and we'll explain why based on the cases. Next slide. So one of the more important cases that have been issued in the past couple of months is the Chamber of Commerce versus Bonta decision. This is a Ninth Circuit case that was issued in February, and it analyzed whether employers can have mandatory arbitration agreements with employees. So that's something where you're requiring employees as a condition of employment to sign an arbitration agreement, presumably with a class action waiver. Back in 2019, there was a statute that was passed that was trying to prohibit these types of agreements. And there was a lot of litigation and went back and forth up to the Ninth Circuit multiple times. But in this decision in February of 2023, then the Ninth Circuit finally found that that statute was in fact preempted by the Federal Arbitration Act. And thus this statute AB 51 is no longer in effect and has no impact on employers moving forward. In light of this case, we think it's completely permissible to have mandatory arbitration agreements with employees. We have clients doing all sorts of different things in that regard. Some are using mandatory arbitration agreements. Some are still calling them voluntary arbitration agreements, but using certain terminology. And then others are allowing employees to opt out of the arbitration agreement under certain circumstances. There's not a one-size-fits-all approach, but in light of this case, we can have mandatory arbitration agreements moving forward. Next slide. Okay, so the next case that we have to discuss before we talk about the cases that have came out over the last couple of months is the Viking River Cruises case, which hopefully you've heard about by now. This was a US Supreme Court case which analyzed the intersection between PAGA and Federal Arbitration Act, the FAA. In this case, the court was addressing California's hostility to private arbitration agreements. And as you'll see in the next slide, it analyzed a number of different cases, Supreme Court cases, and also a California Supreme Court case called the Iskanian case. And I don't want to get lost in the cases, but they're important because they keep coming up in the cases that have developed over the past few years. In the US Supreme Court cases, they have essentially endorsed mandatory arbitration agreements with class action waivers. But there was this Iskanian case going back to 2014 that said that you couldn't force PAGA representative actions to arbitration. Instead, basically, those types of PAGA representative actions would have to stay in state court. Next slide. Fortunately enough for employers, when this went up to the US Supreme Court, the US Supreme Court actually found in favor of the employer in this case and broke the rationale into two different things. It said that with respect to these PAGA claims, there's an individual claim and then there's the representative claim. The individual claim is the individual labor code violation involving that particular employee. And then the representative component is the action that they're bringing on behalf of the state, on behalf of other aggrieved employees. And that distinction is super important as we talk about the next couple cases. Also part of this rationale in the US Supreme Court, it found that you could in fact have mandatory arbitration of the individual PAGA claim. You just couldn't have mandatory arbitration of the representative PAGA claim. But by virtue of this conclusion, the court said that you could compel the individual PAGA claim. And since that employee no longer had standing under California law, then it was appropriate to dismiss the PAGA representative action. So a huge win, right, for employers, because it allowed the ability to force the individual claim into arbitration, then dismiss the entirety of the PAGA action. Next slide. Following this case, employers were following the guidance here and moving to compel arbitration and dismissing the PAGA representative action. But unfortunately, there's been a few different cases that have come out just in the past couple months that are extremely important for the defense of these cases. Two of which are actually reported decisions. And the two reported decisions, Gallersar and the Greg v. Uber Technologies cases, in both of those cases, the court said that the individual PAGA representative action could proceed. And so the courts have essentially disregarded the US Supreme Court rationale and said that rather than dismiss these claims, we'll allow these claims to proceed in state court. And obviously that has some dramatic implications because it forces employers to potentially defend claims in arbitration and then also defend claims in state court. Next slide. As I mentioned, these two cases are important because they are in fact published decisions. So that does mean that that's going to be binding on trial courts moving forward. We think rather than courts dismissing the representative PAGA claim, that there still is a strong basis to move to stay those types of claims. So what you basically want to do is you want to move to compel the individual PAGA claim to arbitration and then move to stay or dismiss the representative claim. We're going to have to see how this plays out. And it's also important to note that there currently is a case, it's the Adolph versus Uber case, which is pending before the California Supreme Court involving very similar issues. So we think that at least sometime in 2023, we're going to have some clear guidance from the California Supreme Court, whether it's good or bad, we'll at least have some guidance in terms of how these claims are going to be addressed moving forward. Next slide. The other cases I wanted to talk about that have came out deal with how courts have been handling cases that are PAGA cases that actually go to arbitration, and then they go through the arbitration process with the arbitrator actually issuing a decision saying that the plaintiff didn't actually suffer any harm. In other words, there were no labor code violations. And the two cases that have come down, one is a case from 2022, the Prime Healthcare case, but more importantly, this case that came out a couple months ago is the U-Haul case. Next slide. In terms of the general facts and the holdings of the Prime Healthcare case, as I mentioned, this was a case where an individual brought PAGA claims on behalf of themselves and on behalf of other aggrieved employees. It went to arbitration, and the plaintiff lost the arbitration case. The arbitrator found there was no labor code violation. There was a simultaneous PAGA representative action, and the employer said, hey, court, you're bound by this rationale, this issue preclusion res judicata principle in California. This issue has already been decided, so you, California State Court, need to dismiss the case in light of this arbitrator's decision. Surprisingly, in this Prime Healthcare case, the court concluded that they were acting in different capacities. And so even though the plaintiff had lost their case in arbitration, they could still pursue it in state court, which is a pretty crazy result. Next slide. So in light of this case, we were seeing an increase of these cases where plaintiffs were saying, even if we lose an arbitration, we can still move forward. It is an unpublished decision, and then along came this U-Haul case, which I'll talk about now. Next slide. In the U-Haul decision, similar to the last case that we talked about, it went to arbitration, the plaintiff lost, and then the issue was addressed in state court. And in this case, the court said that the claims were in fact barred. If the plaintiff lost their individual labor code violation in arbitration, then they were barred from pursuing that case on a representative capacity in state court. So essentially annihilated all of the claims, both in arbitration and the representative component in state court. Fortunately enough, this is a published decision that employers can utilize moving forward and is an important case for defense. We do think that this case is probably going to go up to the California Supreme Court. But as of now, the California Supreme Court has not granted a review of this decision. This is another area that's probably going to intersect with that Uber case that I just mentioned. And we anticipate some more definitive conclusions and guidance sometime this year. Okay, next slide. Very briefly, in terms of another issue that is before the California Supreme Court, is this issue about manageability in defending PAGA actions. And when you boil it down, this manageability issue is something that we would raise similar to how you would oppose a class action. You're saying it doesn't make sense to move forward in a PAGA action where we would essentially be forced to litigate hundreds of mini trials in the same action. And there was a case, actually a Second Circuit case involving Staples, that said that you could raise that type of an argument. Unfortunately, there was a case issued just at the end of this past year, and this was the Fourth District of California Court of Appeal decision, so San Diego, where the court actually went the opposite direction and said that you can't raise these manageability arguments in response to these PAGA claims. Like I mentioned, this issue, because of the court split among the California Court of Appeals, is going to be addressed by the California Supreme Court. At least for now, if you're confronted with these types of claims, you still want to assert a manageability defense in response. But again, we'll hopefully have clearer guidance as we move forward throughout the year. Next slide. Another important case that I briefly want to touch on deals with PAGA in the collective bargaining context. There's a lot of confusion I've noticed from employers about the applicability of this exemption. This exemption has been on the books for a number of years, and basically it exempts PAGA claims if you have certain language in your collective bargaining agreement that would waive a PAGA claim. And there was this Murray Plumbing and Heating Corporation case where basically the employer defended that PAGA action and utilized a collective bargaining agreement that actually covered claims that were retroactive. So going back in time, even prior to the effective date of the collective bargaining agreement. The plaintiffs in this case raised a number of different arguments, and they were claiming that this limited construction exemption for collective bargaining agreements was unconstitutional. It was a violation of due process and a number of other arguments. But fortunately, this decision did find that the exemption does remain in effect and that it can in fact bar PAGA claims retroactively. So taking a look at the next slide, if you have collective bargaining agreements, I would strongly recommend that you consider including the appropriate waiver language as to PAGA claims. There are certain criteria that you need to have in that collective bargaining agreement in order to have an effective waiver, one of which you need to be paying people 130% more than state minimum wage. And you really do need to expressly waive the PAGA statute in unambiguous terms. We see a lot of these types of provisions that would not pass muster and would not be effective and would likely be challenged. So would certainly encourage you to take a look at those moving forward. Before we move on to the next topic, even in the non-union context, again, would strongly recommend you take a look at your existing arbitration agreements, as most of the arbitration agreements that we've seen do not have the appropriate language consistent with the Viking River Cruises case. Also, if you have unionized populations where you do have a collective bargaining agreement, we have negotiated class action waivers in those collective bargaining agreements. Or we've also seen unions being open to side letters or letters of agreement that would be separate and apart from a collective bargaining agreement, but would be mandatory arbitration of statutory employment claims with class action waivers. So a helpful tool to defend against potential class actions and PAGA actions moving forward. Okay, next slide. So shifting gears here a bit, briefly wanted to touch on probably the most important from a practical perspective, National Labor Relations Board decision that was issued a couple months ago. And that's the McLaren-McComb decision. It was a case that arose outside of this industry in the healthcare context, but has equal application here. Essentially, the employer conducted furloughs in response to COVID, and as a part of that furlough process was asking all employees to sign severance agreements in exchange for a release of claims and a certain amount of money. And all of those individuals signed the severance agreements, but the severance agreements had confidentiality clauses and non-disclosure, non-disparagement provisions, which are common in nearly every severance agreement that we see these days. After they signed the agreement, there was a challenge, and unfair labor practice charges were filed with the NLRB, where they were claiming that the mere offer of these severance agreements somehow interfered with federal rights under the National Labor Relations Act. Next slide, please. In terms of how the court analyzed this case, initially it went before an administrative law judge, and then it went up to the 5-member board in Washington that has oversight over these types of labor claims throughout the nation. Ultimately, it overturned a number of important Trump-era cases that broadly allowed employers to utilize severance agreements, including confidentiality and non-disparagement provisions. And importantly, the board found that it has nothing to do with the context in which these severance agreements are offered. There doesn't have to be any unlawful termination. There doesn't have to be any unlawful conduct associated with the offer. As long as you offer a severance agreement that contains these overbroad terms, at least under this rationale, it's a violation of federal labor law. And in this case, the board essentially found that the severance agreements were ineffective and that the employees themselves were ordered to be reinstated, notwithstanding the severance agreements. Next slide. So taking a look at the language at issue in this case, as you'll see, the confidentiality language is pretty standard. We see this in nearly all severance agreements in some form or fashion. Basically, it's confidentiality as to the term of the agreement. You're asking the individual not to discuss the agreement and not to disclose it to third parties, except with a couple exceptions. This was found to be overbroad. Likewise, the non-disclosure provision, also pretty standard. We see these in the vast majority of severance agreements out there. It's basically a provision stating that you don't want the employee saying negative things about the employer or about entities that are related to the employer or officers or directors. Again, this was found to be overbroad. Next slide. So what does this decision mean moving forward? As I mentioned, it applies in all industries, including this industry. It also applies regardless whether you have a union or not. It has nothing to do with unions in general. It has to do with whether the provisions are going to be found to be overbroad, at least under this standard. There's been a ton of questions that we've received from clients about what's the practical implication for this, and what do we have to do with our existing severance agreements? What do we have to do with severance agreements that say we've offered previously, with the past 6 months or the past few years? A lot of these questions have not yet been answered and will have to be addressed through case law. There, however, has been some guidance that's been issued by the general counsel of the NLRB. This is essentially the official who's responsible for prosecuting these labor violations. It's not binding ultimately on the NLRB, but at least the guidance that the GC is giving is that, generally speaking, the 6-month statute of limitations would apply to severance agreements. So if you've offered one in the past 6 months, technically that would apply. But the GC is also claiming that it would also apply to severance agreements that have been rolled out outside of the 6-month period if the employer attempts to enforce those provisions. So it could apply potentially, going back further in time. It's unclear how this is going to play out, at least in state court and federal court lawsuits where employers are seeking to enforce these provisions. But we do think there's a lot of solid preemption arguments that you could potentially raise in response to employees who are trying to circumvent severance agreements based on this decision. We've also gotten a lot of questions, well, can you really draft a provision that meets the standard that's laid out here that still meets our objectives, wanting confidentiality and wanting employees not to say bad things about the employer when they leave the organization? We still do think that you can draft the appropriate provisions. They just need to be narrowly tailored. And there's not a one-size-fits-all approach here. Some clients are being more conservative here, are certainly reworking their severance agreements using different verbiage to exclude coverage under this case. Other clients are taking the risk here because they think the value of confidentiality is more important, and the risk of an employee actually filing unfair labor practice charge may be relatively low. And this touches on the last or second to last bullet is, what does it mean if the severance agreement is found to be unlawful? What's that remedy? In most cases, we think that the severance agreement itself is not going to be completely invalidated. Rather, we think it's just the confidentiality and non-disparagement provisions that might be stricken, but that the general release agreement will still be effective if it's narrowly tailored. That would probably depend on the circumstances, but I think that sheds light in terms of what employers want to do from a risk tolerance. If the worst thing that's going to happen is the NLRB is going to say those provisions are not enforceable, and in order to rescind those provisions, but not the entire agreement. Okay, next slide. So we wanted to touch on the 2023 forecasts just based on the key developments that we've covered in this area. We certainly think that we're going to see an increase in pay equity investigations and class actions based on the new bill that Kayla touched on. And this is not necessarily because employers are intentionally engaging in discrimination, but it's the way that the statute is worded and the way that you need to come up with an appropriate defense in response to these claims. So we're certainly going to see an increase in this area. And as Kayla recommended, strongly recommend that you do an audit to get in front of these types of issues. Certainly think that we're going to see an increase in ULPs brought under that most recent NLRB decision that I just covered. Certainly think that PAGA claims are going to continue at least through 2023 and 2024. I will note though that there is a PAGA ballot initiative. It did qualify for the November 2024 ballot that could amend PAGA and dramatically change the scope of the statute. Fingers crossed on that. The polling is a little all over the place, but at least for now, we think PAGA claims are going to continue. And with that, I'll let Whitney maybe close out the last few in her area.
Great. Thank you so much for all of that, Keen. I think at this point, it's a bit undisputable that California's housing crisis is not going anywhere anytime soon, despite all the legislation that the state puts forward. The actual production of housing continues to be sluggish at best. I think that in 2023, and I think at least beyond for the next couple of years, we can anticipate seeing the legislature kind of mess around, try and figure out ways to address the housing crisis. And I think a number of these bills are likely going to continue to include ways to address prevailing wage, PLAs, and or the workforce requirements that we've been seeing and we discussed a little bit earlier. Despite some of the clarity that the 2021 Supreme Court cases brought, the labor code, I think, continues to be rife with availabilities for different interpretations as to what triggers a public improvement under the prevailing wage law. And I think we're going to continue to see challenges and liabilities faced by contractors as it relates to construction that may include some component of public infrastructure or public improvements as a condition of approval for the development themselves. So I think, at least in the development world, as it relates to the intersectionality with labor and employment, we're going to be continuing to see more of the same until there's some sort of determination and a bright line rule as to how both prevailing wage and public improvements can be applied to private development. Well, thank you so much, everyone, for joining us today. Again, that was a lot, I know, for everyone to take in. We've provided this slide deck to BIA, so if anyone wants it or needs it or would like to go over some of the more nuanced points that were brought up, please feel free to take a look at the slide deck. Our emails are on this slide if you'd like to reach out to all of us directly. I think probably Keen, Kayla, and Kirsten were much more helpful than I, so I direct you to them specifically. But yes, thank you for spending time with us. I don't see any questions in the Q&A or the
I see
chat.
one. I do. I see one hand up. Jamie Jo, can you put your question in the Q&A? There's a little panel on the bottom that has the Q&A. And Jeff Platt had a question also that Keen did answer. But Jeff's question was 100+ employees, what question mark, current employees, year end, etc. Keen, do you want to tell them what your response was?
Yeah, sure. So it's based on the reporting year. So even if you have employees that haven't worked that full reporting year for the disclosures, it would count towards the 100 threshold. So in reality, it's, designed to target employers that are actually much smaller than 100+ employees.
Great, thank you. Jamie, I don't know if you still have a question. I see your hand up, which is a great little feature in this, but I don't see it in the Q&A. So I'm going to think that it was either answered. Now your hand went down, or you can reach out, as Whitney said, because they'll have their emails listed. And thank you guys again for doing this presentation for the SCC. It was very, very informative, and we really appreciate your time.
Thank you for having us.
Thank you, Stephanie.
Anything else from you, Danielle?
No, we're good. Thank you all so much.
All right. Thanks, everyone. Have a great day.